The news that Hee-jin has founded a new company, OK, just days before the verdict in the New Jeans versus Adore contract lawsuit is perhaps the most transparently strategic and frankly, legally fascinating move we've seen in this entire saga. It's not just a business announcement, it's a final, preemptive brief filed in the court of public opinion. As law students, we're taught to look at timing, intent, and the strategic implications of every action. And from that lens, the establishment of OK on October 16th with a verdict due on October 30th is a masterclass in narrative warfare. It's designed to do one thing: create a tangible what's next for New Jeans and their fans, strategically overshadowing the very real possibility of a devastating legal loss. Let's break down the chronology because it's everything. The court's verdict is scheduled for October 30th. Hee-jin registers OK on October 16th. This 2-week buffer is not an accident, it's a calculated campaign. In litigation, every move before a ruling is designed to influence the outcome, either by putting pressure on the opposing party or by shaping the environment in which the judgment will be received. By launching OK now, Hee-jin is probably sending a clear signal to the New Jeans members. No matter what the court says, I have a plan for us. There is a future here. This is a powerful psychological play. It's meant to bolster the members' resolve, potentially making them less likely to consider a settlement or to accept an unfavorable ruling from Adore. For bunnies, it creates a wave of optimism and speculation that can drown out the sobering legal realities, effectively trying to sway the public sentiment tide before the judge even speaks. But this move is a double-edged sword, and from a strict legal strategy perspective, it's incredibly risky. It can be perceived by the court as an act of bad faith. Think about it. The core of Adore's lawsuit is confirming the validity of the existing exclusive contracts. By very publicly establishing a rival entity explicitly poised to take on those same artists, Hee-jin is practically advertising her intent to continue what Adore has alleged all along, an orchestrated effort to take New Jeans. A judge might look at this and see it as confirmation that her intentions have never been to resolve the dispute, but to circumvent it entirely. It's like being sued for breaking a non-compete clause and your defense is to hand out business cards for your new competing company right on the courthouse steps. The audacity is breathtaking, but it's not necessarily smart lawyering. Furthermore, this timing strategically attempts to reframe the entire narrative. For months, the story has been about breach of contract, fiduciary duty, and smear campaigns. The OK announcement pivots the conversation to rebirth, new beginnings, and creative freedom. It's a classic misdirection play. She's hoping the public and the artists will be so captivated by the shiny new object that they forget the foundational legal principles at stake. However, in the solemn, text-based world of a courtroom, where judges are trained to see through emotional appeals, this kind of public grandstanding often holds little weight. The judge's ruling on the 30th will be based on the clauses in the contract and the evidence of breach, not on the aspirational business license of a new company. This move is for the gallery, not for the bench. And the fact that Hee-jin is listed as an internal director is another major red flag for me, and I don't even have to explain why. And besides, the Seoul Central District Court has already issued an injunction prohibiting New Jeans from any independent activities without Adore's approval. This wasn't a minor ruling. It was a preliminary finding that Adore's case had merit and that the company would suffer irreparable harm if the members were allowed to promote elsewhere. This injunction is legally binding. The establishment of OK does not nullify it. It does not provide a magical loophole, and if the members were to sign with OK and attempt to promote, they would be in direct violation of a court order. The consequences are not speculative. They are quantified. The court has already stated that each member would be liable for 1 billion KRW, about $720,000, per occurrence of unauthorized activity. A single performance, a single social media post as NJZ or under the OK banner could trigger this penalty. This isn't a slap on the wrist, it's a financial death sentence for their careers. Any potential investor in OK would have to be insane to pour money into a venture whose primary assets, the artists, are legally forbidden from working and come with a potential $1 billion liability attached to every move they make. The October 30th verdict is about the main lawsuit, which seeks to confirm the validity of the exclusive contracts themselves. The injunction was just a temporary measure to maintain the status quo until this main issue was decided. The most likely outcome, based on the court's prior reasoning in granting the injunction, is that the contracts will be upheld. If that happens, OK becomes completely irrelevant to NewJeans' immediate future. And that is if the members are eventually going to sign with the company. But oh well, on October 30th, the fiction will collide with the facts. The performance will meet the judgment, and no matter how aspirational or emotionally compelling the idea of OK may be, it cannot rewrite the legal text that governs this dispute. This new company may represent a future stage for Hee-jin, but for NewJeans, it is almost certainly a stage they will not be stepping onto anytime soon. So, to bunnies who are currently celebrating this news, maybe don't celebrate too soon yet, because the law, as it so often does, is about to have the final, definitive say.